All right, I've got the little, we're live on YouTube, so I'm assuming we're live on YouTube. This is the Kansas Court of Appeals Zoom docket for June 17th. My name is Gordon Atchison. I'm the presiding judge today. Joining me are Judge Stephen Hill, who is presently the longest serving judge in Kansas. Also on our panel today is Judge Amy Klein, who joined the Court of Appeals several months ago and has a much shorter tenure. I fall in between the two in terms of judicial service, much closer to Judge Klein than Judge Hill. We have one case left on our docket today. That's State of Kansas versus Carrody Buckhorn. If I could have the appearances of counsel, please.
Your Honor, William Skepnick for the appellant.
And for the state?
Your Honor, Emma Halling, Assistant District Attorney for the state.
Thank you. This case is set for standard 15 minutes aside. Mr. Skepnick is the appellant. You're entitled to reserve a portion of that for rebuttal. If you would let me know at the start of your argument how much rebuttal time you would like, we will accommodate that. I will remind counsel that we have read the briefs and are generally familiar with the case. And with that, we'll go ahead and proceed. Mr. Skepnick.
Thank you, Your Honor. I would like to split my time 12 and 3, hold 3 for rebuttal.
That's fine. Please proceed.
Thank you, Your Honor. May it please the court, my name is William Skepnick, and I represent Mrs. Carrody Buchhorn. The state used junk science to dupe a jury into believing an otherwise unbelievable story that a 44-year-old mother of 2, wife of an active military service member with no prior criminal history, no psychological or antisocial history, no history of substance abuse, no history of violence or of abusing children, without any discernible motive, nonetheless placed a 9-month-old child whom she knew and had cared for since infancy face down on the floor of the nursery and stomped or ground her heel into the back of his head. Knowing the child was dead or dying, she calmly replaced the limp body into the bed and began cutting out paper flowers for the other children while she waited for the dead child to be discovered. Only then, for 45 minutes, to frantically give mouth-to-mouth resuscitation while awaiting the arrival of the ambulance. Mrs. Buchhorn was accused because, and only because, she was the last person with the child. The coroner told the jury that it was a scientific certainty that Mrs. Buchhorn had killed the child. His reasoning was that head trauma had been the cause of death. Mrs. Buchhorn was the only person with the child at the time of death. Therefore, Mrs. Buchhorn must have inflicted head trauma on the child.
Well, as we are here today, Mr. Skepnick, what's the strongest argument you have for reversal?
Your Honor, we have several that I think are independently strong enough for reversal. I think the strongest one is the one that has the steepest hill to climb, and that is the admissibility of this depolarization of electrical of nerves in the brain, that it was inadmissible under Daubert, that it is not science and there is no foundation that could have been made to support it, and that in the post-trial hearing, the court's ruling that it passed muster under KSA 456B was error. We believe that there is no scientific basis for this evidence, and it was an abuse of the court's discretion and an abdication of the court's gatekeeper responsibility to—
Let me ask you a question, counsel, if
Yes,
I could. When we are reviewing these Daubert issues, what's our standard of review?
Your Honor, under Smart versus BNSF and Cone, the standard of review is abuse of discretion on the narrow issue of the admissibility of the evidence, which therefore would be whether it is arbitrary, fanciful, or unreasonable, or based on an error of law or fact.
Do
But
we
also-
have to, in our ruling in this particular case, substitute our judgment for that of the trial court in saying that the trial court erred in admitting this testimony?
Your Honor, this court has a de novo capability of reviewing whether the district court actually performed the gatekeeper function or whether the district court abdicated that responsibility. We think that under these facts, the court can conclude that there was an abdication by the district court of its gatekeeper function under the statute. We also believe that there is a clear error of fact or law, and that the decision by the district court on the ruling was actually arbitrary and fanciful.
Mr. Skepnick, you've described the Daubert type ruling as a gatekeeper function of the district court. How is that even preserved when the gate is first pointed to after the trial's been completed?
Thank you, Your Honor.
That's a post hoc determination. That's not a gatekeeper function.
Yeah, yes, sure. In the record of this case, the other reason for reversing this conviction is that the conviction was obtained with inadequate assistance of counsel, and that is that trial counsel failed to object to this evidence and keep it out when it should have.
Well, I would think that's a stronger argument.
I'm sorry, Your Honor.
I would seems to me that's a stronger argument since there was no preservation of the Daubert issue.
Your Honor, I think it's an equally strong argument, and that's why I wavered a little bit when you asked me about the strongest, because I think that there are several. And I think that it's one way or the other on this. And typically the waiver argument on appeal has to do with raising an issue on appeal for the first time. In this case, we raised it with the trial court. The trial court actually took the issue on and ruled on it as a Daubert issue in the post-trial hearings. And so we don't think there's a waiver issue at all here. Now, if the court concludes that there is a waiver problem and that the objection to the Daubert, to the scientific evidence was waived, then it falls directly into the ineffective assistance of counsel in the Strickland test. And
well, I guess my concern is, unless there is some unique circumstance here, my visceral reaction is I don't want an opinion coming out saying that a Daubert issue can be raised for the first time on a post-trial motion. That makes no sense. And so that, I mean, I think there's a significant preservation problem with that issue. And I'm not sure how you get around that, but it folds into the ineffectiveness claim.
I agree, Your Honor. And I believe that when a part of the ineffectiveness of counsel was the failure to raise the Daubert question, necessarily you get into a legal causation issue there. Was the failure to raise the Daubert question, did it render counsel's conduct deficient? And so you therefore get into inevitably whether this evidence was ultimately admissible. And that's, I think it would have been easier for me to take on and just say failure to raise it, ineffective assistance of counsel, Strickland test. But Your Honor, I think at the end of the day, we have to address the harder issue. And the harder issue is whether this scientific evidence ever was admissible. Now,
well, let me ask you, let me interrupt you there. And if I could, counsel.
Yes, Your Honor.
Basically, if this counsel is inadequate, if we conclude that counsel's performance was inadequate, do we even have to say that this evidence is inadmissible? Because if we can set this over based upon inadequate performance of counsel, can we not?
Yes, Your Honor, you can. I believe that the court can, and I understand the court's reluctance to take on an issue that it doesn't have to. But I think the court can take this on. I think it's a great case for the court to give further instruction to the district courts about the proper meaning of 6456 and Daubert. And I believe that the court can give guidance on that. And I think it's squarely before it because we have an actual district court ruling on the issue where she specifically ruled. And so I think it's before the court, but yes, Judge Hill, you're absolutely correct. The easiest way is to simply rule that the failure of trial counsel to effectively confront this issue, and it's like Robinson, or it's like the Mullins case. I mean, there are other cases that, I mean, it falls squarely within the purview of that you can reverse the conviction on that basis.
Well, Robinson was a case dealing with experts.
Yes, Your Honor.
And in this particular case, it strikes me as very similar because there's no witness to what happened to this baby that testified. It was based upon a conclusion made by this coroner, correct?
Correct, Your Honor.
This guilty verdict was based upon a conclusion of an expert. What evidence is there in the record that this counsel contested that opinion?
Your Honor, the trial counsel for Mrs. Buchhorn never addressed this depolarization issue. He never had it researched. He never cross-examined the state's expert with essential, confronted him with that fact and never actually dealt with it. In fact, in the post-trial hearing, we took the testimony of the defense expert at trial, and the defense expert at trial testified that he never was questioned in pretrial preparation about depolarization, and he was never prepared to deal with it. He testified that had he been told about that, he would have told defense counsel that they needed to retain a pediatric neurological expert, as well as that you can't have sudden death from head trauma without evidence of injury to the brain. So, Your Honor, there's ample evidence. And then there's also further deficiency, the failure to obtain the psychological testing. That's an essential part of this as well. Standard psychological MMPI testing shows that Mrs. Buchhorn is not a perpetrator of violence in this case, but is actually a victim of the case by reliable testing, and that her psychological makeup makes it highly improbable that she could have done this, which would have buttressed her testimony at trial that she didn't do it, and would have assisted the jury in resolving this inference that the state wanted it to draw from the fact that she was the only person with the child, which is the only evidence of the case.
In the post-trial hearing, did the trial counsel for your client indicate whether they had made a strategic decision not to raise a Daubert or file a Daubert motion?
Your Honor,
what did they say about that?
They testified that there was no strategic decision, that they simply never thought about it. They never thought of it. It never occurred to them. They blamed their forensic pathologist for not telling them that they should do it. And so they cast the blame on him. They say they testified during the post-trial hearing that had they thought of it, had they been told about this, they would have raised it. So, once again, we believe that now the other issue that I think is worthy of comment at this point, Your Honors, is that is the comment by the trial judge during the jury orientation. which frankly, on a personal level, I've tried many cases in my career, I find shocking. And she basically told the jury that, I want to get this quote right. She said to the jury, she joked with them about the constitutional rights, saying rhetorically why defendants have all the rights and victims have none. Then she answered the question saying, because the people who wrote our Constitution were criminals, and they wrote our Constitution in a way they would have wanted to be protected when they went to trial. And Your Honor, we think this is I believe, based on my experience, that nothing is more critical in the defense of, particularly of a case like this, than the presumption of innocence. And to cynically call that a device written by criminals to protect themselves in the event they would be in the docket themselves, I think misunderstands it both historically and philosophically, and we believe undercuts the significance of the constitutional protection.
Do you think that tainted the trial then for the defendant, because he's one of those people that wants to rely upon those rights? Is that, or she does?
Well, she relied on the presumption of innocence. And I can tell you from my experience trying cases that the presumption of innocence is something that you have to really elevate and explain to juries. And I can think of a recent trial in front of Judge Crabtree over in Topeka, in which, again and again in the course of a complicated criminal trial, he reiterated to the jury the significance of these constitutional protections, particularly the burden of proof. And I think that whenever we make light of them, it makes that reliance really difficult. And I think that it is truly and significantly improper for the court to have done that, particularly in a case like this, where there is literally no direct evidence. The only evidence is this highly speculative theory by the pathologist, and it's so incredible if you really think through what they say she did. And in fact, Your Honor, if you look at the record in this case, she was charged with a greater and a lesser offense, and the lesser offense is what the jury finally, after deliberating for several days, convicted her of, which isn't really consistent with the demonstration of stepping on the child's head in the courtroom, which, by the way, is another problem. And
Mr. Skepnick, our incisive questioning has led you well into your rebuttal time, and actually, well, close to exhausting it.
I learned a long time ago, Your Honor, that what I was intending to say is of no significance, and the only significance is what you are asking me to respond to. So I appreciate your questions.
And you have done that. Ms. Hawley, we'll adjust your time to kind of even it out, because I'm guessing we'll have some incisive questions for you too. And you still have your rebuttal time, Mr. Scott.
Thank you, Your Honor.
I think we'll turn it over to Ms. Hawley at this point.
Also, there's the problem. I don't see the ever-present giant clock in front of me.
Well, I'm watching a very little clock on the corner of my computer screen.
Okay. Thank you, Your Honor.
Go ahead, please.
All right. Thank you, Your Honor. And may it please the court, I would like to reserve 2 minutes for rebuttal.
You don't get rebuttal.
Okay.
You get all your time right now, one shot.
While this case involves emotionally charged facts, the issues before this court are nevertheless constrained by the rules governing preservation and the applicable standards of review. Focusing on these rules of preservation and the applicable standards of review, the appellant does not prevail. First, appellant's challenge to Dr. Mitchell's testimony arises in the context of an appeal of the district judge's denial of her motion for a new trial. This court reviews the denial of that motion for an abuse of discretion. And in cases like the one here, where the district court conducted an evidentiary hearing on the motion, Appellate courts review the factual findings for substantial competent evidence and review the legal conclusions de novo. Thus, the primary issues before this court are whether trial counsel was ineffective for 1, not pursuing a pretrial Daubert challenge, or 2, not challenging Dr. Mitch's testimony sufficiently at trial, including by failing to obtain more expert help than the 3 physicians who were consulted before and during trial. Here, to prevail on her claims of ineffective assistance of counsel, defendant was required to prove that Morrison's performance was deficient under the Strickland standard, meaning it fell below an objective standard of reasonableness. Post-performance review of counsel's performance is highly deferential because of the distorting effects of hindsight. Thus, district courts must indulge a strong presumption that counsel's conduct falls within the wide range of reasonable professional assistance.
Well, that's true if it's a strategic determination. What evidence suggests failing to file a Daubert motion or to challenge the foundation of the forensic pathologist's testimony during trial was a strategic choice?
So Morrison addressed this issue extensively in his testimony and the post-trial proceedings.
I understand that. So
in this case.
what in that testimony shows that it was a strategic decision?
So he testified that he has tried over 150 high-level felony cases. Ms. Craig herself, the defense's expert, testified that she did not know of a single case where Mitchell had been excluded as an expert. It does not follow that under the Strickland reasonable performance standard that we can expect trial counsel to file a challenge that he has never before seen succeed or heard of succeeding in any other Kansas case. So while that's true, it's also the crux of this case is the fact that Morrison picked a comprehensible, fully exonerative theory of defense for Ms. Buchhorn. He consulted with a forensic pathologist in Dr. Wygren, who in turn consulted with a neuropathologist and a pediatric pulmonologist. And that forensic pathologist, seeing all this evidence, said the way that we attack this case is by going after the age of the injury. He got on the stand, he testified about this at length, and this theory of defense is fully exonerative if the jury credited Dr. Wygren's testimony, because the state's theory of the case was that Buchhorn inflicted this head injury on the child and he immediately died.
Let me stop you there. If I understand the record correctly, guilt was based upon the opinion of this coroner, correct?
Among other evidence, yes.
You obviously got a dead child. Nobody saw it. Nobody saw the trauma, if there was trauma. And so the guilt was based upon this depolarization theory. Is there any evidence in the record that counsel talked to the defense experts about depolarization?
Yes, Your Honor. To be frank, Morrison says in his trial or in his post-trial hearing testimony, which is record volume 8, I think we're talking around page 170, that he talked to Wygren about the depolarization theory multiple times over the course of multiple conversations. Defense counsel's accusation here that Morrison never had those discussions with Wygren is based on Wygren's testimony. At these post-trial hearings, then we have conflicting testimony between Morrison, who says, absolutely, we talked about this theory, and Wygren, who says, I don't think we did, but I don't have a direct recollection of our conversations and I'm recreating it from notes. Obviously, based on this conflicting testimony, District Judge Buckhorn credited Morrison's testimony in reaching her ruling on this case. And
Counsel, but didn't Morrison testify that he asked the expert about the depolarization theory but didn't get a response?
That is not my recollection of the record. I remember him saying he dedicated his conversations with Wygren were always covering the age of the injury, the goose egg, and depolarization. And that conversation is at some point in record volume 8. I'd be happy to follow up if I can find that site for you. But he said multiple times he discussed depolarization. Wygren didn't even want to talk about it because Wygren was so convinced that the age of this injury was fully exonerative. If he could just get before the jury that that injury had aged could not have been inflicted that day, then Buchhorn was home free.
So am I correct that basically counsel chose to present two ships passing in the night? We're not even going to attack the state's theory. We're just going to go forward with ours, and we're going to let the jury pick which one is more plausible?
I disagree, Your Honor. I wouldn't characterize that theory as disregarding the state's theory, because if you're saying that Buchhorn didn't inflict this injury, that's directly attacking the state's theory, because the state's theory is premised on she hit this baby in the head and that baby died. So if you can say it wasn't her that hit the baby in the head, couldn't have been, then it's fully exonerative.
But they didn't present any direct response to the depolarization theory from any expert, did they? They didn't try to debunk it with any expert testimony?
No, they didn't, because if the injury timing is off, you don't even need to address depolarization. And that—
But it's not inconsistent, is it? I mean, you could do both.
Yes, I suppose you could try and belt and suspenders it, but that is not what Strickland requires. Strickland requires a vigorous, robust defense. The defense that Morrison put on here was very good and, quite frankly, makes a lot of sense. If the jury credits this timing issue that was well supported by Wygren in his testimony at trial, then Buchhorn didn't commit the offense. If we get into a battle of the experts about depolarization, that's assuming that a jury is going to follow that very well, be able to suss through it, and decide for the defense on that issue. I think it makes a lot of sense for a trial attorney who has a lot of experiences with juries who are 12 lay people to say, I'm going to pursue the theory that people will understand. And it doesn't make a lot of sense for us to be Monday morning quarterbacking and saying, no, 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 this fully exonerative, logical, well-supported theory, that's not a good defense. Instead, you should have gone afield with this highly technical defense. And the fact that you didn't do that constitutes ineffective assistance of counsel.
Doesn't the record show? Oh, I'm sorry, Your Honor.
No, go ahead. Finish up.
Correct me if I'm wrong, but doesn't the record show that the trial attorneys didn't do any independent investigation of the depolarization? They simply relied on Wygren to do that for them. Am I missing something?
That's not entirely true. Morrison testified that after the preliminary hearing, he did online research on depolarization. I don't believe he went into detail about what all he found in that, but that testimony is in volume 8 of the record.
And did he use any of his Google results of the trial?
I do not believe so.
Counsel, I was going to ask you a question about the, it seems to me, cynical comment made by the judge during the voir dire. Is this something that you defend?
It's an off-color comment, to be sure. The state's position is that it did not affect the jury's verdict in this case. It was at the end of jury orientation. We had a week-long trial. We had a jury that was properly instructed, and there's a strong presumption that juries follow the instructions that are given to them, absent evidence to the contrary. And to be frank, in the scheme of comments, what the judge was doing, more or less, was comparing the defendant to the founding fathers. And there are far more prejudicial people that you can be compared to than perhaps the most lionized figures in American history.
As I understand the comment, they're criminals. And so if she is in that position, she is now a criminal. Is that right? And so if you find that acceptable, I'm a bit shocked.
I mean,
that you would. It's simply more than off color, counsel. It's blatant, is it not? It's saying if you seek the constitutional rights, you're a criminal?
I don't believe that she is making that equivalency. She said that the reason that criminal defendants under the American system have such robust protections is because of who set up our system and their motivations at the time. She wasn't saying—
You're much more eloquent. You're much more eloquent than she was. I'm trying to think about, we've got this person in a black robe sitting in front of these lay people, as you talked about, these 12, and saying, well, these criminals rely upon the Constitution. And we've got a defendant there who is presumed innocent, and we've got the judge saying criminals rely upon the Constitution. I found it a bit shocking.
I understand, Your Honor.
I'd like to jump back to the expert witnesses issue. And do you believe that the doctors Kessler and Ning, who were the neurologists who testified at the post-trial hearing, would have been qualified and allowed to testify as defense experts in the trial?
I believe that they would have been able to testify as experts about neurology. They would not have been able to testify independently about cause of death because neither expert was a forensic pathologist. They didn't have strong backgrounds in forensics, and they weren't able to draw a conclusion about Oliver's cause of death. So I think that the defense may have been able to bring them in to talk about depolarization, but not to talk about ultimate cause of death.
Well,
And
would they have been able to testify that depolarization, as the state's expert described it, doesn't square with their understanding of brain injuries and has no support in the medical literature that they're aware of?
Well, in this hypothetical, I would like to note that at these post-trial hearings, both experts admitted that they had not watched the autopsy video. They had not reviewed all of the medical records in this case. And so I think if that remained the case in this hypothetical scenario, then they would not have been allowed to because they would not have had all of the facts before them on which to issue an opinion. For the sake of this hypothetical, I assume that the defense would insist that they be adequately prepared at trial if they had the full benefit of all of Oliver's medical records and the autopsy and things like that in this case. I do think they could have opined on depolarization at trial, but now we're in a double hypothetical scenario.
Well, yeah, but you also have Mitchell testifying at the post-trial hearing, and he can't cite any literature supporting his theory. And he says, well, I think I saw something like this in 2 autopsies I did, but I can't remember anything about them. Is that a fertile ground for a reasonable doubt about the reliability of Mitchell's testimony in front of a jury?
Your Honor, first of all, he didn't say that there was no literature supporting his theory. The state introduced multiple textbooks that discussed.
I think there were articles, and I think he conceded that they didn't directly support the notion of depolarization as he was describing it, didn't he?
There was also textbooks that were admitted. The name escapes me currently, but there was a chapter that talked about laboratory tests that had been done in animals with spinal head injuries that didn't result in brain trauma. And one of the things that Mitchell discussed when he was discussing this textbook was the fact that there is a lack of studies supporting this theory because forensic pathologists can't just go, conducting what we would consider a normal scientific study. They can't go inflicting neck and spinal injuries on people and seeing what happens to their brains after they die. It's unethical, it's not plausible, such is the nature of forensic pathology. He discussed that issue in this hearing while bolstering his credibility with the discussion of the 12,000 autopsies he's committed over his career, hundreds of which were children, his almost decade on the Child Death Review Board.
Okay, well, I understand that he's had a very extensive career and he's done lots of autopsies. But it brings me back to my question is, if you had Kessler and Ning testifying at trial, is that a counterweight sufficient that we may have some doubt about the outcome of the case at this point under Strickland, under the prejudice prong of Strickland?
No. That
And why not?
That does not establish prejudice under Strickland because it would involve an assumption that the jury would automatically credit and conclusively credit both of those experts over Mitchell as an expert, which is a matter of weighing credibility. And this court can't just go in and say, there's no way that a jury would have agreed with Dr. Mitchell. On that.
But that's not the Strickland test for prejudice. It's whether the circumstances are such that there's a reasonable possibility or probability that there might have been a different outcome. It's not that there would have been a different outcome, isn't it?
Well, if we're talking about this in the Daubert context, the reality is.
Well, I'm talking about it in the Strickland context in ineffective assistance.
Right, but the argument here is that it was ineffective assistance because he did not file a Daubert challenge to Mitchell pre-trial, correct?
Well, that's not the question I'm asking you, but I mean, that may be the question you want to answer.
No.
I mean, the question I'm asking you is if they went ahead and retained those neurologists and presented their testimony, regardless of whether they challenged Mitchell pre-trial, is that enough to say there is some possibility or a reasonable probability that the outcome might have been different? Not that it would have been, but that it might have been, which is I think the test for prejudice under Strickland.
So
that's what I'm getting at.
Yes, the complicating factor here is that Strickland's prejudice and performance prongs overlap in the context of motions that were not filed because it hinges on the meritoriousness of that motion.
The motion's irrelevant. I'm saying whether they filed the motion or not, if they had called those neurologists, the evidence would have been different and there would have been a counterweight of some sort to Mitchell's theory, which there wasn't in the actual trial. Is that sufficient to suggest prejudice under Strickland?
Oh,
it has nothing to do with the motion. The motion could have been denied.
I see what you're saying. So you're not talking about the failure to keep Mitchell out. You're saying, is it ineffective assistance that he didn't call these experts at the trial court level beyond
right
that? Okay, I apologize. It took me a while to get.
I probably didn't make myself very clear, but I mean, this is a complicated case. It's got a lot of moving parts. So go ahead. Now that I think we're communicating, why don't you answer my question?
Okay. Apologies. It took so long to get there.
No, I made it my fault.
It was not ineffective assistance of counsel to not call these experts because Morrison was pursuing an entirely viable defense to this case. And again, all the jury would have had to do is credit the theory that they are much more likely to comprehend and understand the timing issue as compared to these experts. The Strickland standard of review is such that practitioners will always wish that they could have done something different after a trial, particularly if it's a trial that they lost. But that's not the issue. The issue here, Morrison put on a robust, viable, winnable defense. Yes, would it have been better for him if he had called those experts? Quite possibly. Does that rise to the standard of ineffective assistance of counsel? No, it doesn't, because it doesn't meet the performance prong. And in terms of prejudice, that hinges on an assumption that the jury would have been more likely to reject Mitchell's testimony based on that. And that is just such a far afield assumption for this court to be making, ex post facto.
All right. You have gotten to the end of your extended time because of our incisive questions and some kind of flubbed up questions from some of us. If you want to just take a minute or so to sum up your position, why don't you go ahead and do that?
Sure. In conclusion, it's easy to stand here after an adversarial, highly emotional trial and use the benefit of hindsight to speculate about what could have gone differently. But the fact of the matter here is that Morrison did provide Buchhorn effective assistance of counsel. He presented a defense, the aged injury timing defense, that, if believed, would have fully exonerated Buchhorn. He supported this defense with expert testimony from a forensic pathologist, who in turn consulted both a pediatric pulmonary pathologist and a pediatric neurologist. And Morrison further bolstered his defense by ably attacking Mitchell on cross-examination. Morrison provided effective assistance of counsel under the Strickland standard. As the Kansas Supreme Court has held, the primary purpose of Strickland is to ensure the defendants receive fair trials. This trial was fair. The state requests that this court affirm Buchhorn's conviction.
Thank you. Mr. Skepnick, you have 3 minutes of rebuttal.
Thank you, Your Honor. I'm going to go back and talk about Wigrin. I think that a great deal of your questioning to counsel for the state focused on that, and I think it needs a little bit of clarification. Dr. Wigrin testified at the post-trial hearing, and he testified that on issues such as depolarization of neurons or any neurological injury such as this, that pathologists such as himself rely upon neurologists. And so they would consult with a neurologist to find out what the problem was. He testified that had he been told that there was a that this issue was, depolarization is actually nothing that anybody knows, but had this issue been raised with him, he would have told them that they needed to hire a pediatric neurologist, and he would have told them that that neurological injuries such as this don't occur without evidence of injury to the brain. So he on that issue, Dr. or Mr. Morrison said that he had raised it with Dr. Wigrin, but the issue was raised in the preliminary hearing, and it was in the preliminary hearing transcript. And Dr. Wigrin testified he never received the preliminary hearing transcript. And in fact, the testimony at the post-trial hearing was that the preliminary hearing transcript was never actually sent to him. So it's very clear that the issue was not developed. Alice Craig, who is our expert witness on lawyer standards, testified that if you didn't get an answer to that question, the standard of care would be that the lawyer would pursue that issue with the expert witness, so that if he didn't get an answer to the question, he can't go to trial without an answer to the question. And in fact, it's sort of significant that in the trial on cross-examination, the counsel for the state asked Dr. Wigrin a question about whether or not there could be instant death from a blow to the head. And Dr. Wigrin said, yes, but. And then when he tried to do the but, counsel for the state cut him off, and the trial judge said, well, you could go back into that on redirect. Then on redirect, Mr. Morrison didn't go back into it, leaving the jury with the impression that instant death can be caused by a blow to the head. And when asked at the post-trial hearing why he didn't go back into it, Mr. Morrison said, well, I didn't know how he would answer the question. That's ineffective assistance of counsel. I've tried hundreds of cases. That's ineffective assistance of counsel to leave the causation question, the central issue in the case. There is no case here without Dr. Mitchell's testimony, to leave the causation question unexplored, undeveloped. And Your Honor, I know that, I don't want to go into all the Rivas thing, but
you've gotten to about the end of your time. Why don't you give us the elevator pitch here real fast? And it's not a tall building,
Your Honor.
So.
Your Honor, I'm too old a dog to believe that my elevator pitch will serve any purpose. I know the court is quite familiar with the record, and we believe this case is an injustice, and that we understand that there's a desire to blame somebody for such a horrible event. But blaming Mrs. Buchhorn doesn't make it better. It exacerbates the horror of this event.
Thank you both, counsel, for an instructive oral argument. This is, as you've indicated, a challenging case. We'll take it under advisement and get out an opinion as soon as we can. With that, our oral argument docket is adjourned.